The court's going to consider an emergency situations in which harm is happening to a party or to a child of the parties that the court cannot wait to take action on. So some situations are going to be when another parent who's caring for children has been the subject of a Baker Act or a Marchman Act or poses some other kind of threat to a child, a threat that may be of abandonment, of neglect, including medical neglect, and physical abuse. In talking about what's not an emergency, those are going to be oftentimes the frustrations that parents have as it relates to time sharing and not getting time sharing, even if there's a prior agreement. It's going to further relate to issues of child support, whether or not the payments are set too high for one parent. You may feel that that's an emergency that the court needs to immediately address. However, the court is going to assume that the payment that you're making is the proper amount and won't find that to be an emergency. Likewise, the court will also not find to be an emergency payments that are not being made to the other parent. So situations that oftentimes parents find themselves in that can be incredibly frustrating and even perhaps somewhat traumatic to that parent, the court will not find to be an emergency unless and until there is actual harm to a child or to property. In Florida, when we file supplemental petitions for modification, we can't ask for temporary relief unless and until it becomes an emergency situation. The court's going to assume that any prior judgment that's in place that outlines a parenting plan and a specific time-sharing arrangement or decision-making arrangement was the proper parenting plan to implement. However, if something becomes an emergency, for example, a parent's mental health that could become a problem while caring for the children, substance abuse that impacts the child as well, or exposing the children to criminal activity that also may impact the child's well-being, those types of situations will be addressed by the court in an expedited manner. Now, in some cases, DCF is going to come in and file an action, and that's going to be heard in dependency court. However, sometimes DCF may not be taking action, or it may be in your best interest to also file an action in family court to have a family court judge also be aware and advised of what's going on. Either the court will hear the evidence and will issue a ruling that will take effect immediately, and that ruling will remain in effect until it reaches a later ruling following a trial, or the court will deny that, and then it's up to the party to decide whether or not they still want to go forward and present the case to the court at trial. It's important to have an attorney to guide you through the process and represent you at court because of the fact that the court is hearing your matter on an expedited basis, and the court's going to expect evidence that's competent, that can be admitted, the court can consider. It's important to be able to present that in a timely manner before the court. Oftentimes litigants are nervous, and when that happens, they tend to ramble on, and that can eat up a lot of valuable time that could have been spent better presenting your case. So it's essential to have an attorney represent you at an emergency hearing in order to ensure that you can tell your story to the judge and tell it well.